Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. If policy whiplash and mounting caseloads are draining the joy from your practice, you're not alone. You became a lawyer to help people build new lives, not to drown in paperwork and rework cases amid shifting political winds. That's why the experts at e-Immigration by Serenade created the Certainty Factor, a free guide showing how purpose-built AI tools can create stability in your practice without sacrificing the human touch. Featuring insights from top innovators in immigration law, Serenade is sharing ways to implement AI so you can be a strategic advocate again. Download the Certainty Factor today at get.eimmigration.com/certainty and put the heart back in your practice. That's get.eimmigration.com/certainty or click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Big news out of the Fourth Circuit this week. By the way, hello everybody. Anyway, big news! The court ruled in favor of the National Association of Immigration Judges and against acting EOIR Director Cersei Owens in a dispute that I must concede does predate Ms. Owens' helm as acting director. The IJ Association challenged a policy that required IJs, quote, to obtain permission before speaking publicly on issues relating to immigration, end quote. The district court dismissed the suit below because some claims must first travel through an administrative process established by the Civil Service Reform Act. And that does remain true. But, quote, it is not clear that the Civil Service Reform Act is currently so functioning, end quote, to the Fourth Circuit. Flat out, the Fourth Circuit doesn't trust the executive. Quote, serious questions have recently arisen regarding the functioning of both the MSPB and the special counsel. We cannot allow our black robes to insulate us from taking notice of items in the public record, including relevant here, circumstances that may have undermined the functioning of the CSRA's adjudicatory scheme, end quote. Wow. So it sent the case back to the district court to see if review is possible. Never forget how important unions are, everybody. Or I guess associations, whatever the IJ thing calls itself now, due to legal necessity. Also this week, the Fourth Circuit joined the 3rd, 5th, 8th, and 11th Circuits to find that it lacks jurisdiction, quote, over challenges to USCIS's adjudication hold policy regarding final date retrogression for adjustment of status applications, end quote. That whole Indian visa priority date retrogression thing that happened a couple of years ago that we keep talking about. Oh, and by the way, kind of also in the Fourth Circuit, they brought back Kilmer Abrego Garcia, giving a complete, utter, and sanctionable lie to their professed inability to do so for months. Months. To save face, the administration has done so under federal indictment in what appears to have led to the resignation to the head of that local office's criminal division. Time will tell, of course, whether these new facts alleged against Mr. Abrego Garcia are correct. But man, what an embarrassing saga. Now, on to the rest of the illegally deported people suffering in that gang prison in El Salvador. And on to these 5 cases. First up is Hadwan v. Department of State, published by the Second Circuit on June 3rd, 2025. This is a wild case about passports. Judge Menashe dissented. Mr. Hadwan, quote, is legally a natural-born United States citizen who has been stranded in Yemen for the past 12 years, end quote. That's how it begins. We're in for a wild 42-page ride, folks. He was born in Yemen and lived some of his life in New York and California. Looks like he had children in Yemen and, in 2013, traveled there to apply to get them to the United States. He has not since returned, since 2013. At some point during his hours in the embassy staff took his U.S. passport and took his Consular Report of Birth abroad, known as a CRBA. So he was in deep. 9 months later, in Yemen, he received the formal revocations of both of those documents based on alleged false statements made to obtain both. It's been 12 years fighting that now, from civil war-torn Yemen. But he has now won a procedural victory that should at least bring him back to the United States. Stepping back, according to his CRBA, the Consular Report of Birth abroad, Mr. Hadwan's father was a U.S. citizen at his birth, while his mother was Yemeni. Mr. Hadwan got his CRBA when he was 10 years old in 1998 and used it to get a U.S. passport when he was 16, so presumably his parents did these things for him. Importantly, quote, the issuance of a CRBA does not grant citizenship. It simply certifies that a person was a citizen at birth. And issuing or revoking a CRBA does not change the underlying circumstances of an individual's birth and does not affect an individual's citizenship status, end quote. It's just kind of the proof. Now, according to the Department of State, Mr. Hadwan admitted during an embassy interview that the documents were based on false information, and that his father wasn't really his father, but was instead a relative who had smuggled him into the U.S. as a child. Apparently, Mr. Hadwan, the embassy officer, and a witness signed a confession statement. So that looks pretty bad. Mr. Hadwan, however, claims he was deceived into signing that document. And what else does the State Department have? They mentioned an investigation 9 months later, but what did they actually do? That seems to be what Mr. Hadwan's been trying to figure out through administrative procedures and lawsuits for 12 years. To challenge taking the CRBA, it first goes through an Office of Passport Services hearing with the Department of State, which it seems is an adversarial agency proceeding. Mr. Hadwan's attorney got one continuance during those proceedings. But when State Department counsel objected to a second continuance, the State Department hearing officer rejected the request. As the basis for the continuance request, counsel was saying it was really hard to get evidence from Yemen. If you know, you know, I suppose. Mr. Hadwan himself, of course, could not attend the hearing in D.C. State could have actually let him, but they refused 3 times. As such, his attorney could not communicate with him directly or get evidence, which could have even included DNA evidence to prove that Mr. Hadwan is the elder Hadwan's son, explained the Second Circuit. No affidavits were submitted either. So all that happened was that they argued about the signed statement, including the lack of translation and some other issues. The State Department hearing officer upheld the State Department's decision. A federal lawsuit and 3 amended complaints followed. Mr. Hadwan lost, and he appealed to the Second Circuit. Mr. Hadwan has also tried to apply for 2 new passports, by the way, in the interim, but now there isn't even an embassy in Yemen to do that at. Also, and I don't know, seems pretty important to me, this Department of State officer in Yemen who was part of this signed statement has been sued before, and there is a Department of State Inspector General report from 2018 that, quote, provides a detailed description of a pattern of wrongful passport revocations in the Sana'a embassy in that period, end quote. Wonder how Mr. Hadwan got that. See what happens when you actually permit discovery against state? 30 people out of 31 examples of this officer doing what he did to Mr. Hadwan to other people that, quote, failed to comply with relevant standards and regulations in retaining and ultimately revoking the passports, end quote. Mr. Hadwan, quote, alleges that he is individual number 31 in the OIG report, end quote. Unreal. And by the way, this wasn't known at the time of the Department of State hearing. Again, the district court ruled for state below, but that was reversed by the Second Circuit, which held that state had violated the APA and the U.S. Constitution. First, because, quote, undisputed facts in the agency record established that Mr. Hadwan could not read or write English, and that the confession statement did not include any competent certification that it was read to Mr. Hadwan in his native language, end quote. And second, quote, the State Department violated Mr. Hadwan's constitutional due process rights by revoking his travel documents and abridging his rights to travel without providing him with any meaningful opportunity to be heard, end quote. Oh, Mada. Let's take the Administrative Procedures Act first. It all, after all, came down to that confession. And well, the Second Circuit doesn't love it. It's undisputed that the dude couldn't read or write English, for example, so he couldn't have possibly prepared the statement himself, explains the court. Other issues too, including no affidavit or other information from the officer of how it all went down. All, of course, under the cloud of the Inspector General report against that officer for 30 violations. Yes, the signed statement says that Mr. Hadwan's signature is on the document affirming that it was read to him in Arabic, that he understood it, and that it is his signature. But, quote, an argument that a statement in a foreign language was not signed knowingly is not disproven merely by pointing to the content of the statement itself, end quote. Anyone else thinking about notices to appear or voluntary departure agreements at the border? Just me? Plus, although there are signatures, at other points in this signed statement, there are just the initials HH. But Mr. Hadwan's name is Mansour. Shouldn't that be MH? And he signed the document Mansour Hadwan. To be fair, his full name is Hadwan Mansour Abbas Hadwan. But then why not sign it as Hadwan Hadwan if you're going to initial it HH? Too weird for the court, and more importantly, the State Department never addressed this, and the review here is, quote, whether the agency properly supported its decision, end quote. Gotta love the APA. On to then the constitutional due process and Fifth Amendment claims. Quote, Mr. Hadwan's CRBA and passport conferred upon him a constitutionally protected interest in his right to travel. By revoking these documents without providing Mr. Hadwan with any meaningful opportunity to be heard, the State Department deprived Mr. Hadwan of that interest without due process of law, end quote. Lots of reasons why, but this is a long one, as you can already tell. Suffice it to say, state has a whole framework to facilitate people like Mr. Hadwan back into the United States to attend their revocation hearings. By failing to do that here, they prevented him from being heard on this very important constitutional right, particularly as it seems that no one has security concerns about Mr. Hadwan. So, let him in for his hearing. By the way, it seems like revocation hearings can occur overseas now, but it's too late for Mr. Hadwan, and anyway, they're not happening in Yemen at present. So the Second Circuit has directed the Department of State to return the CRBA and expired passport to Mr. Hadwan, quote, so that he may reapply for a new United States passport without prejudice if he so chooses, end quote. And then, I don't know, sue again if they deny him? Wild stuff. Judge Menashe believes this case is straightforward, a denial, but he is not in the majority. Can't wait for that DNA evidence and Hadwan Part 2. But for now, congratulations Julie A. Goldberg for appellant. And that is Hadwan v. Department of State. Next is matter of BNK, published by the BIA. This case was accepted by the BIA in the quite rare context of an interlocutory appeal. Although not so surprising, given I'm not sure how else this issue could get to the BIA. It's about administrative closure and recalendaring. Quite timely, as ICE is engaged in a nationwide effort to do this with all administratively closed cases, I believe, which I suspect the BIA is aware of. Ms. BNK is in immigration detention, and in May 2024 filed a motion to admin close her removal proceedings based on her pending application for temporary protected status. An immigration judge granted that motion, apparently based on a mistaken belief that it was a joint motion with DHS. Apparently it wasn't. DHS did an interlocutory appeal, but the BIA declined to accept jurisdiction over it at the time because it was an interlocutory appeal. That is, an appeal before removal proceedings have definitively concluded. DHS then moved to recalendar the case, which that same IJ denied. DHS then interlocutorily appealed that, which the BIA, a new BIA, has now accepted. And now it has sustained DHS's appeal. Quote, administrative closure is intended to be a docket management tool used to temporarily remove a case from an immigration judge's active calendar or the board's docket, end quote. It is not a form of immigration relief, and it doesn't give a non-citizen true status in the U.S. IJs have been doing it for years, and the process was formalized in the BIA's 2012 decision matter of Etizian and later matter of WYU. Jeff Sessions hated admin closure and tried to get rid of it in matter of Castro-Tum. Many circuits overruled Mr. Sessions, and then Attorney General Garland vacated Castro-Tum. And towards the end of the Biden administration, administrative closure was formalized by regulations at 8 C.F.R. Section 1003.18. Importantly, and unlike in matter of WYU, that regulation states that, quote, no single factor is dispositive, end quote, on whether to administratively close a case or not, which I would presume includes DHS's opposition. WYU, in contrast, had made DHS's opposition quite important to whether or not to administratively close a case. Given all that, this is quite the paragraph. Quote, the regulations provide a list of factors to consider in determining whether to administratively close or recalendar a case, but they do not prescribe the manner in which the factors should be considered in relation to each other. Although the factors must be considered in the totality, and no one factor is dispositive, the regulations do not require immigration judges and the BIA to give each factor equal importance, end quote. Also, the current BIA throws some shade on matter of Etizian in a footnote. So it looks like the BIA thinks that some factors for administrative closure and recalendering might be more important than others. After all, explains the BIA, the role of the IJ and the BIA is to determine removability and relief. It is not to exercise prosecutorial discretion. And, quote, there is an important public interest in the finality of immigration proceedings, end quote, a factor I don't believe that the regulations mention. As such, to the BIA, quote, the basis for granting administrative closure must be related to achieving some foreseeable resolution to the ongoing proceedings within a reasonably short period of time, end quote. It shouldn't be used to delay proceedings indefinitely. And as such, quote, whether there are persuasive reasons for a case to proceed and be resolved on the merits is the primary consideration in determining whether administrative closure is appropriate under the totality of the circumstances, end quote. And in a quote that I'm sure will be relied on heavily going forward, quote, while a party's opposition to administrative closure is not dispositive, IJs and the BIA should carefully consider the reasons for the party's opposition, end quote. In a footnote, the BIA explains that it is taking great pains to save as much of matter of WYU's focus on a party's opposition to admin closure as is possible, notwithstanding the new regulation expressly superseding WYU's holding that the persuasive opposition of a party is the primary admin closure consideration. Seems like the BIA is trying to save matter of WYU. Pretty sure if this panel had their way, they would have written Attorney General Garland's regulation differently. But that is simply a guess. Applying those new and clarified rules here, the BIA believes the IJ erred in not recalendering proceedings. DHS never agreed, explains the BIA. Now, the BIA doesn't believe admin closure appropriate in the first place. That Ms. BNK has a pending TPS application doesn't really help because a non-citizen can get TPS even if ordered removed. Reasons the BIA. The BIA explains that here there are, quote, persuasive reasons for removal proceedings to be resolved on the merits, end quote. TPS is temporary, explains the BIA. There is an interest in resolving Ms. BNK's pending asylum application, and again, someone can get TPS with a final order. Plus, Ms. BNK is detained, something that will often not be present and that the non-citizens bar should use to try to distinguish this case from the recalendering floodgate that is about to begin. Quote, in the administrative closure context, where there is often uncertainty as to the duration of the closure, a non-citizen's detained status is of particular significance and will generally counsel strongly against a grant of administrative closure." End quote. Ooh, but the BIA knows where I was heading. Are you listening, BIA members? You can admit it. Quote, "Although the respondent's detained status supports our conclusion that administrative closure is not warranted in this case, the result here would have been the same, even if the respondent were not detained." End quote. Oh my. Flat out, quote, "A pending application for TPS generally will not warrant a grant of administrative closure." End quote. Come forth, ye floodgates of recalendaring, for the potentially hundreds of thousands of admin-closed cases for TPS recipients and applicants, and dare I say, over 1 million more admin-closed cases generally? Who knows? But let's be clear-eyed, non-citizens bar. This is a decision designed to neuter opposition to motions to recalendar. Go back and read 8 C.F.R. section 1003.18 and its factors and make a strong showing on at least one of them to support your opposition, because this is a decision you will need to overcome. Reaffirming matter of WYU to the maximum extent possible despite the regulation, the BIA remanded the matter for reinstated removal proceedings. Here's one nugget before we move on. The BIA may have again created an unworkable paradox here. As you may have heard, the BIA has instructed IJs to consider administrative closure where it will only be for a relatively short duration. But as we learned during the Castro-Tum litigation, the circuits are quite concerned by the fact that administrative closure is literally required by regulation for a non-citizen in removal proceedings to pursue a Form I-601A waiver and consular processing. It was largely for this reason that many circuits declined to follow Castro-Tum last time around. But as we all know, 601A adjudications are now taking upwards of 4 years, and non-citizens control absolutely no part of that. If IJs are about to start relying on the agency's own 601A delay as a basis to deny agency administrative closure for something that the agency's own regulations mandate must happen to get an I-601A approved by the agency, well, we're going to have some litigation. I say resist the urge, IJs, and continue to administratively close cases for I-601A adjudication. U visas too. And that is matter of BNK. Last one before a break. Singh v. Bondi, published by the Second Circuit on June 3rd, 2025. This case is about asylum and credibility, and involves the Second Circuit's somewhat special Ramsameachire framework for border interview pseudo-transcripts from 20 years ago. And I'm sorry if I butchered that name, and I might do it again throughout this decision. Judge Menashe, writing for a somewhat split court, has used the Real ID Act to effectively overrule the Second Circuit panel's decision in Ramsameachire. What a world. Bad facts do make bad law. Here, Mr. Singh admitted that he lied to the border officer on the advice of his smuggler many years ago, but that his testimony in immigration court was true. Not so much about the substance of his claim, though, to be honest, but rather about the journey he took to get to America. Honestly, the first story seems more harmful to his claim than the second, so I'm not even sure why the discrepancy is so bad for Mr. Singh, other than the fact that he is admitting that he told an untruth at the border. The crux of Mr. Singh's claim is a Man Party Sikh asylum claim from India. He testified that he was a member of the Man Party and that he was harmed and threatened by the other main Sikh political party, as I understand it, the Badal Party. While the Second Circuit notes some minor discrepancies in footnotes in the statement in chief, it seems that the substance of Mr. Singh's claim was pretty consistent throughout his border interview, I-589, and in-court testimony. As you can gather, the IJ denied based on an adverse credibility finding. About the border interview discrepancy, Mr. Singh mentioned that he was depressed and pretty scared at the time of the border interview, having been taken to 2 or 3 places by CBP officers and told by his smuggler not to, quote, tell the correct thing to anyone. It will not be good for us and not good for you, end quote. I guess about the smuggling techniques and countries used? I don't know, I might be nervous too. Assuming it was true, of course. The IJ did not believe Mr. Singh and believed that it affected his credibility as a whole, applying the Real ID Act's totality of the circumstances standard to credibility determinations, even if, as here, the discrepancies don't seem to go to the heart of the asylum claim. Although the IJ did actually believe it went to the heart of the claim, and, quote, goes to respondent's willingness to be truthful and honest in his dealings with U.S. government officials, end quote. Rejecting or finding not persuasive some other evidence, the IJ denied. Relying on Ramsameachire and matter of Barcenas, Mr. Singh appealed to the BIA. But relying on its own precedent, the BIA affirmed the IJ. As I mentioned, an effectively split Second Circuit affirmed the BIA here. The Second Circuit agrees with somewhat recent BIA precedent recognizing, quote, a presumption that interviews of this nature are proper to consider in an adverse credibility determination, end quote. That is, the non-verbatim reports of border interviews contained in Form I-213s and other similar documents. Now, binding Second Circuit precedent, Ramsameachire, quote, relied on the opposite presumption, that a border or airport interview is not proper to consider in an adverse credibility determination unless it bears sufficient indicia of reliability to warrant its consideration by the agency, end quote. So what changed? Heck, we just talked about Ramsameachire and its required procedures on episode 175, Poma via Zarumba v. Garland. So the framework was all still good law, less than 2 years ago in the Second Circuit. Well, explains the panel, the Real ID Act was passed by Congress after Ramsameachire, and of course well more than 2 years ago. While the Real ID Act included a very important credibility statute, that statute said nothing about border interviews. But it essentially lets adjudicators consider the totality of circumstances when making an adverse credibility finding, and, attacking primarily the Ninth Circuit, stated that discrepancies need not go to the heart of an asylum claim to support an adverse credibility finding. Applying that statutory change, explains the Second Circuit, an IJ can consider a border interview non-transcript and any discrepancies just, I guess, as it could consider any other piece of evidence, without any of the generally non-citizen-friendly protections from Ramsameachire or other requirements that seek to prevent non-citizens from what could be unreliable hearsay reports of border conversations. To the court, the Real ID Act's totality standard, quote, displaces the judge-made standards that had previously been developed, end quote. But you still gotta consider all factors, IJs. You can't just rely on a border interview non-transcript, I would think. But what do I know? Indeed, in quite the agency deferential quote, the court holds that as the BIA is technically a party to the litigation and not like a lower court on appeal, quote, we are authorized to provide remedies against the agencies as a party to the dispute, but do not oversee it as an inferior judicial tribunal, end quote. The Second Circuit believes its new rule for border interviews and adverse credibility aligns with the First and Fifth Circuits at a minimum. And of course, with the non-inferior tribunal decision from the BIA in matter of JCHF. Sure, explains the Second Circuit, an IJ can consider the Ramsameachire factors if he or she wants, but the IJ no longer must. Without that procedural argument, the panel didn't have trouble affirming the IJ and the BIA's adverse credibility finding here. It didn't like that Mr. Singh had lied about how he traveled to the U.S., nor does it see error in the agency's rejection of his argument that he was under duress at the time. Not enough explanation of that from Mr. Singh at a minimum. As such, the I-213 was properly considered by the agency, which had the border interview non-verbatim statements reflected therein. And Mr. Singh lost his case. Judge Perez concurred to state that there was no need to essentially vacate Ramsameachire to rule against Mr. Singh here, that the agency had applied that decision well enough, and all of this could easily have been disposed of against Mr. Singh by non-precedential order had Judge Menashe wanted to do so. And that is Singh v. Bondi. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Continuing on with Linares-Rivas v. Bondi, published by the Fifth Circuit on June 3, 2025. This case is about non-LPR cancellation of removal and ineffective assistance of counsel. Kind of. Mainly jurisdiction and exhaustion. Mr. Linares-Rivas has lived in the United States for nearly 30 years. He's from Mexico. He's removable for entering without authorization, but he landed in removal proceedings because of a driving without a license arrest. Having been here a long time and with 2 U.S. citizen children, he applied for non-LPR cancellation of removal. But he missed the IJ's deadline to submit evidence. Counsel submitted it 3 months late, and well, the IJ still considered it. That was a month before the merits hearing, and then former counsel straight up dipped. The reasons are not explained. Mr. Linares-Rivas appeared at the merits hearing a month later with new counsel, who said that he was prepared but also requested a continuance to submit additional evidence. New counsel blamed prior counsel. The IJ did not grant a continuance, held that the Lozada requirements had not been met against prior counsel, proceeded to the merits, and denied relief. 2 DWI convictions and no taxes paid, it seems, for example, and no requisite hardship. The BIA affirmed. And at the Fifth Circuit, well, it held that it lacked jurisdiction. Yes, Wilkinson now permits review of whether agreed facts meet the exceptional and extremely unusual hardship standard. But one basis relied on the IJ here to deny was pure discretion. That Mr. Linares-Rivas wasn't a good dude. And that is not reviewable. Straight Patel and I&A Section 242A2B. Rough stuff. On then to ineffective assistance of counsel and the denial of the continuance. But Mr. Linares-Rivas apparently didn't bring those arguments to the BIA. Alleging due process violations to the BIA does not cut it, explains the Fifth Circuit. Gotta be more specific. And even if his notice of appeal might have raised the issues with specificity, it seems. Quote, the BIA was not required to consider issues listed in Mr. Linares-Rivas' notice of appeal, but not raised in his subsequent appellate brief, end quote. And it means here, in a pretty short one, that Mr. Linares-Rivas remains ordered removed. And that is Linares-Rivas v. Bondi. concluding the week with Hesea v. Bondi, published by the Fourth Circuit on June 4th, 2025. This case is about aggravated felony sexual abuse of a minor convictions and crimes of child abuse, two separate ways for a lawful permanent resident to lose their LPR status. The crime here is a federal one, a plea to one count of coercion or enticement of a minor under 18 U.S.C. Section 2422B. Factually, it was serious stuff involving a 14-year-old girl. 276 months in prison, sentenced. Well before that time passed, it seems, DHS initiated removal proceedings, which Mr. Hesea contested. The IJ and the BIA deemed the conviction removable under I&A Section 237A2A III as an aggravated felony at I&A Section 101A43A, and additionally as a crime of child abuse at I&A Section 237A2EI. Here, the Fourth Circuit affirmed that. The categorical approach applies, of course, which is pretty good for Mr. Hesea. Quote, if we were to look at Mr. Hesea's conduct, as admitted by him, there would be no doubt that he engaged in sexual abuse of a minor and child abuse, end quote. But the categorical approach is, of course, statutorily focused on the minimum conduct criminalized. The first argument here, as always, was one based on the Supreme Court's Esquivel-Quintana decision. In that case, the court analyzed Section 101A43A in the context of a statutory rape offense, and held that such crimes are only aggravated felonies if they require, as an element, that the victim be less than 16 years old. Here, in contrast, the federal conviction permits a victim to be 16 or 17 years old. But, distinguished the Fourth Circuit, like many courts before it, including the Fourth Circuit and other panels, this is not a strict liability statutory rape offense at issue in this case. This is in fact nothing like that. This instead requires, quote, the defendant to have knowingly persuaded, induced, enticed, or coerced a minor to engage in sexual activity, or to have knowingly attempted to do so in the active pursuit of libidinal gratification, end quote. Explains the Fourth Circuit, neither the narrow scope of Esquivel-Quintana nor its rationale supports extending that decision to crimes like this and requiring a statutory victim age of less than 16 years. In the regular non-statutory rape context, the sexual abuse of a minor aggravated felony describes crimes that require a, quote, perpetrator's physical or non-physical misuse or maltreatment of a minor for a purpose associated with sexual gratification, end quote. To the court, that includes the conduct criminalized here, quote, crimes involving indecent communications with a minor, sexually lascivious nude exposure to a minor, and photographing a minor in sexually explicit postures, end quote. Nor does it matter that the mens rea, or mental state, required of this crime only really applies to trying to entice the minor rather than to sexual contact itself, or that convictions can occur where the victim is actually an undercover cop. Because, it seems to me at least, the Fourth Circuit is holding that Section 101A43A itself might encompass attempts under the right circumstances. Now, the attempt aggravated felony provision is a separate provision at I&A Section 101A43U. And so I'm not sure if the Fourth Circuit is ignoring that the I&A Section 101A43U aggravated felony allegation must be charged in the NTA. I don't know, I am a bit confused. Seems like some things might be getting fudged or not fully explained procedurally in this decision. But anyway, the Fourth Circuit sustained the aggravated felony allegation. Turning then to the separate removal allegation for a crime of child abuse, the Fourth Circuit affirmed that too. That removability provision describes crimes with one, quote, a culpable mental state, and two, an act or omission that causes harm or creates a reasonable probability of harm, and three, to a child, end quote. Here, but again, because the mens rea applies only to the act, not to the child's age, and attempts qualify if the completed offense would qualify as a crime of child abuse. While there are many reasons discussed in this decision, at base it seems the Fourth Circuit explains that even mere solicitation of a minor and nothing else can cause sufficient harm to a child and was properly intended to be protected by Congress. It appears that the Fourth Circuit gets around the fact that it could be an undercover cop as a victim again by noting that attempts will qualify for this removal provision as well. And so, the court affirmed removability in a bit of a complicated one. And that is the Singh v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.